So welcome to the Commercial Literacy Workshop, which is provided very generously by the Royal Society of Entrepreneurs in Residence, Pete Hotten, Adrian and James Otter. Today we'll be talking stories from the front line of commercializing IP. So this is actually the second session. The first was last week, covering a basics course. And if you, this will be referred to during the workshop. If you'd like the slides for that, I can send them out to you. So just please email me. My name is Harry. For those who don't know me, I'll be chairing today. I'm part of the industry engagement team at the Royal Society. I'm joined by the rest of the team, the Kyriakos and Katie. If you'd like to give a wave, I don't know if you'll be able to see them anymore, but
hi everyone.
You can say hello. So before we get started, a little bit of housekeeping. This workshop will be recorded. It may capture your image or audio. If this is an issue, please let me know. Audio is quite easily solved and we'll be able to cover over any stray video feeds. I'll be muting all mics. If you'd like to ask a question, please either type out the question in the chat box and I'll read this out, or write a question and I'll ask you to speak. Temporarily unmute yourself, hold down the space bar and you'll be able to speak as well. So please note, this session is designed with the intention that the speakers are interrupted. They are really insistent that you do interrupt them with questions. So please ask questions during the session. So I just want to talk about the commercial literacy workshop a little bit. So the idea of this is to use the opportunity of the reason we're running this is to use the opportunity of the coronavirus lockdown to share the commercial expertise of the Royal Society of Entrepreneurs in Residence. Through the process, we'll build up a library of standalone material useful to a range of audiences for the Royal Society. So we'll be able to share this all in future with you. It's very informal. It's based on lived experience, and each session is modular. So it's self-contained, but will provide a thorough course. There we go. We intend to send out pre-reading per module, and if you registered at the right time, you should have got that in the joining instructions. And we're intending to run this every week on Friday from around 10 AM to 11:30 PM. This might change in terms of length depending on how people find this, but it's designed to be regular. We won't be running it next week as it's a bank holiday, but after that we'll continue on. So we've had in terms of content, there are 3 levels. The introduction was done last week. We're now into the core modules, and there will also be specialist sessions. So without any further ado, I'll hand over to our EIRs to introduce themselves, starting with James Otter.
Okay, good. My name is James Otter. I'm the Royal Society Entrepreneur in Residence Southampton at their Institute for Life Sciences. I've been around a bit, got experience, 16 years of which with a kind of blue chip world in Zeneca Agrochemicals, which took me all over the world. And then the last 20 years I've spent either leading or fixing or investing in technical SMEs. And you can see by the list, I've done a range of different things. And what really interests me is why the British are so good at building proper companies. And that's really where the idea of the course came from. I've spent 20 years as a director of boards as well. I have, for those who are interested in academic stuff, I did a natural sciences degree a long time ago at Cambridge, and I did an MBA at a business school in France called INSEAD. And pre-commercial stuff, pre-children ideas with NGOs in Africa, and that's me.
Hello, yeah, my name is Pete Hotten. A bit like James, I've wandered around for a long time, 30 odd years in business management, and 17 years in total in different places, building up tech transfer capability in universities and companies as well, because tech transfer from company to company is also important. It's not just an academic thing, it's a commercial thing. And also some time spent heading up the tech transfer type activities in the UK MOD. for my sins, I spent 10 years as a main board director in a biotech, which is where I learned an awful lot of the stuff that you're going to be hearing about today. And this biotech was really quite interesting because we built it all through IP strategy. And in the last few years, I've been a one-man consultancy company trying to convince people I know a little bit about management, IP strategy, and company creation. And on the academic side, PhD in microbial enzymology. So I tend to do life science type projects, but what I have found is that life sciences needs engineering. So over the years, I've become a little bit more informed about the engineering aspects of applying life science technology. So, and that's me.
So we're also joined by Adrian Burden. So he is a entrepreneur who's co-founded a company called Singular ID. He's also the founder of Malvern Festival of Innovation, the co-founder and CTO of Blockmark Technologies, and he's also written an amazing book called Start to Exit, which was handed out actually last November in the Industry Fellows Networking event. So with that in mind, we'll now start the first session, which I've now lost. There we go.
Okay, so last time I was talking a little bit about the basics of IP. So it's an introduction to what IP is and the different forms of it and some of the differences you get in different countries and the scope of IP, which is actually very, very wide. It's not just patents, there's lots of other different forms of IP. And as Harry said, I'm sure you can get hold of that material from the Royal Society if you'd like to have a look at it. And I will be referring to it occasionally. But from the commercial point of view, just knowing what IP isn't enough. You've really got to understand how IP can impact across the company in almost all of its aspects. And if you don't really understand the rather intricate and sometimes confusing, but hopefully not always, way in which IP can impact a business, you're not always going to make money. In fact, you're going to lose money. And there are many, many case histories, and I'm going to touch on one or two, where people had great IP, but they didn't have what I call IP awareness, how to really integrate that into proper business thinking. So one of the things which I hope comes through this talk is not only do you have to have a good idea of what IP is, but you also have to have solid business sense, and you ought to take really good advice so you can build up the right experience, so you can use this knowledge about IP to actually boost your business. And just to give an indication of what I mean by IP awareness, I've got here a little schematic of the average headings in an average business plan. And you've probably seen many of these if you're interested in commercializing things, because people always say, well, what's your plan? What are you going to do? And if you actually put down these headings and then start to fill out the paragraph or two, then a chapter, it will build, and you'll start to get the idea of what the business is. But IP, if you do talk about IP at all, and in this talk, I'm going to talk mostly about patents, but you can make similar arguments for other classes of IP. So if you're in a technical company, one of the companies, for example, that James would be working with, quite often, if IP is mentioned, it's mentioned as a subsection under technology, and it's just talking about, we have this patent, that patent, and the other. And it's almost like we have a bundle of paper that weighs 10 kilograms, so we must be good, without actually understanding what that bundle of paper really allows you to do. But I would argue, if you're really IP aware, IP considerations actually touch and impinge on almost all of those chapter headings, certainly in the products, because if you look into the patent databases, you're going to find out an awful lot about people's technology and product ideas. Market, well, where are those patents relevant? You might be blocked from some markets and not others. The business model, are you actually a complete provider to the market? You do your own R&D, do your own manufacturing, you do your own logistics, sales and marketing, or not? And IP can impact upon all of those things. We talked about technology. Financial modeling is interesting. Quite often, if IP is mentioned in the finances, it's normally a one line, and we say, oh, let's put down a budget for 30,000 for patents. Well, that's not very sophisticated. Not only do you have to understand what the cost of engaging with patent agencies, the cost of patenting, but you also have to understand the cost of the team that you need to actually work those assets. You also have to understand the cost of defending them. And there's a lot of financial modeling that you should do around IP if IP is in fact going to be a major part of your business. Sales and marketing, I'm going to leave that for a moment because I've got quite an interesting example to speak about how IP awareness and the sales and marketing function in one particular company was dysfunctional, and therefore that company lost a lot of money. Clearly, risk assessments and IP come together because what is the risk of other people having IP or risking your freedom to operate? Competitor analysis, because you can find out, if you know about how to use IP analytics, and we'll come on to that as well, you can find out who out there has actually got the patents, who are the competitors, and so on and so on. So what I'm saying is that IP awareness actually impinges, in my view, across most of the company. And in fact, one of the things that I do in the consultancy work that I offer is when I go into companies and I ask them what IP they've got, they say, oh, I don't know. And they go off somewhere and they get someone who is the IP manager. And the IP manager knows, but no one else in the company knows. And so I always suggest that simple processes are put in so that the company can readily identify what IP it has. And then I put in questions what you're going to do with it, and I give them rationales about how they should approach the IP, because all companies will have IP. So the purpose of this first slide is just to set the scene where the introduction to IP, as spoke to last week, is one thing, but unless you actually combine that with a proper business sense of what the company is in its entirety and actually consider how IP impacts across all of these things, then you're never going to be optimal in running the business unless you understand these things. So Harry, if we can move to the next slide, please. Right, so now slightly more focused, I'm going to talk about IP strategy. Now, IP strategy is a subset of the overall business strategy, and you should never forget that you have a business, and the business vision and the business model and the business plan is paramount. IP is a part of that, but you should have an IP strategy, but it should align with the overall business strategy. And if it doesn't, then something is wrong. Either the business model is wrong or the IP strategy is wrong. And when you consider how should I make up an IP strategy, what's it all about? Well, I've given a few indications here of 6 aspects of an IP strategy. First of all, do you know what you've got? How do you secure the IP that you've got? Do you keep it secret or do you formalize it? And we talked about formal IP and know-how and secrets last week. You have to actually understand the scope and limitation of what IP rights are. And again, we talked to that. But unless you understand that, your IP strategy will be flawed. So yeah, timing and place. You might have some IP which is really forward thinking, and you should think very carefully about when you use it. Because if you, for example, patent it, within 18 months, it'll become public knowledge. And if you've done it too early, the market won't be ready, but you've already alerted your competitors to what you've got. So something which a lot of people don't always give enough consideration to is the timing and place of when to apply, when to use the IP assets, when to formalize them, when to take them from the secret know-how into formalized assets, and how to introduce them into the market. Similarly, deal formats. There are many variations of deals that you can do using IP as an asset or as a part of the deal. And I'm going to be talking about licensing in a moment or two. But there are very many other things you can do. For example, if you're really focused on your own business, but you do think that you've got IP which might be of interest to people, you can use what are known as IP brokers, who will help you find others who might be interested in your IP, but in fields and applications and territories which don't impinge upon your main business. Talked briefly previously about costs. So acquiring, maintaining, defending. There are a lot of costs associated with IP. You need to think those through. And finally, I'll just repeat that the strategic and tactical planning must relate and be aligned with the overall business model. So these are some of the considerations that I would advise that you take on if you want to really understand how to use IP properly. Can we use the next slide, please? Right, we talked about licensing. So you've got to be careful in licensing, and I'll show you why in a minute. But don't be afraid of it, because it is a great way of leveraging your IP assets to make money. And in some cases, and I work for a company, for example, where we had loads and loads of IP, but we didn't have any products because we were quite ahead of the market and we were at cutting edge point. But we also didn't have much money. So we actually funded the company entirely through out-licensing, a whole series of non-exclusive licenses. And by that means, although it was organic growth and reasonably slow, we eventually grew to be a company of 100 odd people, but we never needed venture capital, private equity, or other sources of income. We did it all through IP strategy. And we also did it in a way that preserved our core fields and territories. So what I would argue is that don't be afraid of licensing, but be aware that it can also cause your downfall. And I'll show you why in a moment or two. So let's go to the next slide. Right, now the table on the right hand side of that slide, if you like, gives some of the sections that you should find in a decent licensing agreement. There's a lot of them, and I'm not going to talk about them all because that would take me forever. I'll do a whole different set of lectures on licensing, but I'm going to just pinpoint one or two. And even all that great list of things isn't all of the sections that should be there by any means. And I mentioned some of the other things on the left, the sub-licensing warranties, the field descriptors, etc., etc. Now, as I say, don't be frightened of these things. There are people out there who can help you if you need help, but it is important to understand what all these sections do and what the implications are of getting any of those sections drafted incorrectly. I've ringed there a couple of sections which are really to do with the IP part, and some of the case studies I'll talk to will touch upon the intellectual property rights to infringe, etc., and how that can be a good thing, or if you're not careful, how it might be a very dangerous thing. So next slide, please, Harry. Right, one of the things that you need to be aware of is sub-licensing, and this is simple maths, really. You agree a license with a licensee, so you're the licensor, and you've licensed licensee A. You think this is a great deal because they're going to be selling products and you're going to get a 10% royalty. During the negotiation, licensee A was quite smart, and he explained that his business model required him to actually get sub-licensing rights. Okay, you thought, well, you give that, that's not a problem. So if licensee A were to sell £1 million of licensed product directly, you, the licensor, will receive £100,000. However, if licensee A sub-licenses company B and company B sells 1 million, and let's assume that the 10% royalty flowed through from B to A, then A would get 100,000, but he'd only owe you 10% of that. So for those £1 million of sales, you'd only get 10,000, not the 100,000. And this is an incentive to companies who've got sub-licensing rights to have all sorts of side agreements with their sub-licensees and their sub-sub-licensees, whereby they get an awful lot of value, but the original licensor is losing value hand over fist. So be careful about sub-licensing rights. There are ways in which sub-licensing is good and you can overcome these problems. And a simple way of overcoming this problem is say, yeah, you can have sub-licensing rights, but every time you sub-license or sub-sub-license, all sales must be treated as if they were made by the licensee A themselves. In other words, the licensor always gets 10% of the royalty of whatever products were sold by whoever the sub-licensee or the sub-sub-licensee were. I mean, that's just one way around it. But just be careful, because this is an example of how you can lose quite significant amounts of money if you don't really understand how these clauses work. Can we have the next slide, please? Another great one, and this has been the downfall of lots of people, is enforcement against infringement. If you go out and you find a licensee, and the licensee is very interested in taking a license, but comes back with a very reasonable point that the license only has any value if the licensor actively pursues infringers. In other words, what's the point of me paying for a license if other people are using this technology and you're not going after them to stop them? It's a very reasonable point. So some licensees will try and insist on clauses that say the licensee has the right to inform the licensor of any suspected infringement and that the licensor is obliged to take action. But if you accept that, you, the licensor, will go bust. Why? Because the licensee is going to warn you of company 1, 2, 3, 4, 5, 6, 7, etc. In every case, you will then be obliged to take action. And that is going to cost you money, a lot more money probably than the licensee is paying you. So the net result is, even though it was your technology and your IP, because of the terms of the license that you've signed, you're actually going to bankrupt yourself. So just be a wee bit careful about that. And on the next slide, I'll give a possible solution. So the solution is to actually understand negotiation and to actually understand the implication of different terms. So any agreement should be of mutual benefit. In the previous slide, I kind of spoke of the licensee being a bit clever and a bit more smart than the licensor. But if the licensor really knew his business, then you could actually include terms which effectively state as those positions as I put on that slide. So though the licensee is to inform the licensor must not take any action. And the reason why the licensee must not take any action is because that would be an incentive for them to lose the action, because then the patents will become invalid and then he doesn't need a license to operate. So that's kind of important. And it's also important that the licensor has sole discretion whether to take action or not, and that the licensor can settle on any terms it likes. But in doing that, if it settles in terms which are better than the licensee has, then the licensee can adopt those new terms. And you should also insist that the licensee is obliged to help the licensor. So if the licensee is really worried about these infringement actions, then you need the licensee to help you to get the information if you are going to take any action. The reason why the licensor, i.e. you, the patent owner, should always be in control is because it is typical that if you take out an infringement action, the defendant, one of their first claims will be that your patents are invalid, therefore they're not infringing. So patents are always at risk, or normally always at risk, during infringement actions. So these are just some of the pitfalls and some of the solutions. But as I say, if you understand this, then licensing is a very powerful tool to leverage great value from IP. Can we have the next slide, please? Right, so the first of a few case studies is represented by this particular slide. Here we had a small UK company, happened to be a spin-out from Oxford University. It had actually been running for, let me think now, about 3 years before I joined it, but it didn't have any employees. It had the professor who founded the technology as a board director. His wife, but that isn't as bad as it sounds, because she was a very clever PhD qualified life scientist in the right area, also as a director. And as a shadow director, who always refused to admit he was a director, but he was a shadow director. And I advise you to have a look about shadow directors. What are they? Can they get away with things which they think they can, but they can't? And I'll refer you to a future course, which I'm sure James Otter will talk to, who was a lawyer. And what they'd done, we had the academics who were perfectionists. We had the lawyer who pointed out all the things that could go wrong, which is fair enough for a lawyer. Net result, they'd run up a lot of fees and they hadn't done any business, and they were about, should we just say, a lot in debt. But I was aware, and they were aware of me, and I knew that they had a really great portfolio of key patents. I knew they had a very small bank balance, no product and market, and I went and joined them as a director of this company and came up with the business strategy, which was to have multiple non-exclusive licenses in an attempt to get money to fund this company. So we engaged in licensing discussions with many companies, but there was one very significant player on the block, happened to be a VC-backed US company with an established market presence. They appeared to be infringing, and I'll talk about appear to be infringing in a bit, and they refused to take a license. Now this became reasonably well known in the industry that this major significant player was refusing to take a license. So this caused an issue. that other companies we were talking to, although we were still talking to them, they were using delaying tactics to actually wait and see what we would do with this US company. Because if we couldn't get them, the US company, to take a license, other people will simply say, well, you're not going to go after infringers, why should we bother? So what was the solution? Well, the solution is, and often the case, that you ought to take the best professional advice you possibly can. If you're going to take any kind of action, and I'm talking about legal action here, you really got to think about it very carefully. You really got to think about, well, what are the downsides and what are the potential upsides? The downsides are almost always more certain than the upsides, but please get the very best professional advice you can. So we engaged with some really first-class advisors. We took out some of the best UK lawyers, and we engaged with some of the, if not the top IP litigation lawyers in the US. And at the same time, part of the strategy was to develop really strong relationships with larger companies who wish to enter the market. So in the engagement with the first-class advisors, we built up a very strong case. And actually proving infringement is not particularly easy, and you do need to have a good body of evidence. So just suspecting infringement isn't good enough. You need to do your homework and do it very well to actually prove it. And that would be the subject of a different talk, so I'm not going to go into that particularly. But in parallel with that, we started building up some very strong relationships, and with one company in particular, we entered into a number of product development and licensing agreements, which strengthened our cash position. So that enabled us to actually initiate the litigation. And that's a very important point. We initiated the litigation, but we also kept talking to the US company, because if you can, you want to avoid getting into court. You also want to show that you're serious, and initiating litigation doesn't necessarily mean you've got to go all the way through to get to a court judgment. But what it does show is that the other side doesn't come to some agreement with you before that stage is met. You will get to a court judgment. Now, court judgments themselves are kind of worrying, because you're never quite sure what the judge is going to say. Even if you think you've got a really strong case, sometimes judgments come out which make you think, how the heck did they get to that? Because it wasn't really as good as you hoped for. Anyway, we went quite a way down the litigation pathway with this large, not the large US company, but the company that refused to take a license. And shortly before the final decision was due from the courts, they actually agreed a settlement with us. So the result actually was very, very good, although it took some time and a lot of money to get there. The US company that refused to take a license became licensed, and therefore we got an awful lot of license fees because they had a large market share and they were doing very well. We in the UK further strengthened our cash position, and it was very interesting how many other companies quickly fell into line and took licenses once we won that big battle. So the strategy there was to really understand the litigation process, to actually use that as a really strong incentive for talks, commercial talks to continue, to take it all the way, to not give up, even though everybody on the other side tried to delay as much as possible. Don't give up, keep going. And if you do things smartly, you should win if you have a good, strong case. Having a good, strong case, however, you have to really understand what that means. This is why you need those first-class advisors. If we can go to the next slide, please. So, just a quick one, and the answer's in the slide, but if I had asked you what do FM radio, light bulbs and rubber tyres all have in common, you probably would have scratched your head for a few moments. But the quick answer is that these were important bits of technology and therefore a large potential commercial opportunity. Whenever you have a large commercial opportunity, there's going to be competition from lots of different people who want to share or maybe even want to dominate those markets. And therefore, you get lots of people who try patenting, lots of people who actually claim that the fundamental invention was theirs, and you get into patent wars. And this can drag on through the courts for years, literally for years upon years. And all of these people I mentioned, from Armstrong down to Goodyear, they all suffered from patent wars. It cost them a lot of money. And not many of them some of them, but not many of them, use smart strategy. So a lot of them actually ended up impoverished and in debt, and some actually committed suicide. It's quite interesting, actually. I don't know, this is a side thing. Charles Goodyear was never successful in his lifetime in commercializing his vulcanization technology to the extent that he should have been. And he got very depressed about this. And the Goodyear company was actually set up 40 years after he died, which was an interesting observation. Another interesting observation was that Armstrong of FM radio technology fame, he was a great inventor. He invented all sorts of things, but he didn't have any business sense. He was actually offered a very good deal by a particular company, but he refused it. Unfortunately, Edwin died, but shortly after he died, his wife, who had a bit more business sense, even though she wasn't an inventor, actually went back to that same company and did a great deal. So she actually made a lot of money out of it, whereas the inventor didn't. So just remember that having IP is a beginning and a cost. Having the right business model is key to success. And I think at that point, but Harry, if you can move on one slide. I think
Pete, we've actually got a question. So a question from Steve Morgan. Could you have afforded to go through with litigation, or was it a gamble?
Sorry, there was a lot of noise there, Harry. Can you say the question again?
Sorry, could you have afforded to go through with litigation, or was it a gamble?
The only reason we could afford to go through with litigation was because of the deal that we did with the multinational that wanted to enter the market. So we entered into product development deals, and we gave them a really nice form of license. But part of that deal was they gave us a lot of cash up front. So we bankrolled ourselves to go through the litigation. And just to give you a feeling of what you need to bankroll yourself for, if you go through the US infringement litigation thing, if you go all the way through to court, we're talking about millions of dollars. We're not talking hundreds of thousands, we're talking millions. So you have to actually have a strategy that puts the cash in the bank, because you will bankrupt yourself if you don't have the cash in the bank and the opponents drag out the process, and they will drag out the process. The example I gave you wasn't quick. It actually took place over a number of years before the eventual result came through. So you do need to be very savvy on the financial side, because there are many things that can go horribly wrong. And one of the things that can go horribly wrong is you run out of money. So hopefully that answered the question.
Thanks, Pete.
Yes, I had a quick question. I'm not quite sure if it's so feel free to defer it to another time, because it's not quite on patents, but more IP in general. And from one of the courses, the Royal Society training courses, an interesting thing that came up was the use of copyright in terms of open source software, but as in my use of it. So we were discussing the other day about a spin-out company from the university, and obviously I'm in a computer science background, so our main part of that would be the software, but around the tools that we produce, we use a lot of other open source software. And it sort of seemed that I was being quite naive about how we could go and transition. Like, in the university group, that's not a problem at all, but in a startup, making use of all those tools, how do we do it properly and protect ourselves? And
right, well, can you hear me?
Yeah.
Yeah, okay, yeah, it's actually a very interesting subject. What you have to do is you have to go into the open software license conditions, because there should be a terms of use document that goes along with all open source software. In many cases, they are people who have open source software are very happy for you to use it for your own research and development, but they're not always happy for you to make commercial gain without you actually having a commercial license with them as well. So whilst it's open for you to do exploratory things, but not always for commercial things. So have a look at those terms and conditions of use. And you're quite right, loads and loads of people fall into this. They think it's open source software, therefore I can use it for what I want. But copyright still exists. But actually copyright and software is very interesting, because the copyright bit is if you actually use it directly as they code it. if you understand the functionality and you've got your own coders and you actually code your own programs, it's almost inevitable that the code strings that you use will be different. You might even be using a different language. So you get round copyright issues that way, but that often takes ages and ages to write those programs, which is why the open source software is very interesting. But my recommendation is look very closely at the licensing terms, which normally are given when you access open source software, and simply comply with them and contact the suppliers of it, because they normally are actually more than happy to give you rights to commercialize it, so long as they get what they consider to be an appropriate benefit.
Cool. Thank you. So I just had one follow on, if that's okay. In that, one of the things that was surprising, or someone had told me, and then I'm not quite sure if it's true, is that even when a company has sort of said it's available under sort of LGBL, or it's available for commercial use, they could change that. You still need a signed license with that particular provider.
Right. I would always recommend that whenever you use intellectual property, which comes from a third party, you have a written agreement which gives you permission to do it. Even if that written agreement says, yes, you can do it and it's all for free, have it in writing.
So that would still apply if it was a sort of framework from Google or someone like that, where
it's general advice. Yeah. To get into specifics is beyond the scope of this.
Yeah.
But yeah, that would be my general advice, that if you're using intellectual property, and software is a form of intellectual property, and copyright isn't normally the issue with software. It's just using their product. But I would always get a written document which confirms that you have the right to do what you want to do.
Perfect. Thank you very much.
Brilliant. Thank you. Adrian, are you able to speak? Is your mic working?
Yes. Hopefully you can hear me now.
We can hear you. Brilliant.
Thank goodness.
Should we start again?
Great. Yeah. So I'm ready to start when you are. Absolutely.
Okay. We're past 10:41, so we're ready to go.
Okay. Well, good morning, everybody. Thank you, Harry. And thanks for stepping in earlier with the tech challenge at this end. I don't know what the problem was, but we've got the microphone now. So also thanks, Pete, for the overview a minute ago about the different considerations of IP. What I'm going to do in these 4 slides is just take you through an example that I was heavily involved with as a spin-out company in Singapore. Let me just give you some context about this as well. So it was a materials-based project, and I was working at the Institute of Materials, which is part of the A-STAR family, Agency for Science, Technology and Research in Singapore. And although it is in Singapore, actually there's a lot of similarities with how things work here in the UK. So A-STAR is a bit like EPSRC or RI UK as it is now. And IMRI is really an applied research institute. We don't really have those in the UK, but it's very much like an applied university laboratory. And so I was out there working on some projects with some co-investigators, and we came across some materials technology that we thought would be really useful for a different application. So very quickly, the micrograph you can see there of lots of little holes or circles is actually anodized alumina that was being developed for hard disk drive applications. And we realized that this was actually like a unique fingerprint, and a materials-based fingerprint that we could use as a unique identifier. And so we did a bit of work on this within a research project within, if you like, the university setting, and realized that this material could be used in a commercial world as a way of stopping counterfeit products. A bit like we have a fingerprint on the end of our finger, we could create a unique materials fingerprint that could go onto products and packaging. And so what we did within the research institute, employed by the Singapore government, if you like, with research grants and so forth, is took this forward within the lab setting, and we filed 2 patents. And I've put down there a little bit, if you want to go and look them up, and so you can have a little read about what we were trying to cover there. But as you can see, a couple of things. First of all, I've put there that they are US patents. Normally when you file your first patent, you're almost obliged to file it in the country in which you're making the invention. So here in the UK, you'd file a GB patent. In Singapore, we got special dispensation to file our first patents in the US directly. And we did that for a strategic reason, because we wanted broader coverage. Although the Singapore IP system is very similar to the rest of the UK and Europe system, obviously it's a very small home market in Singapore, and we wanted to have our initial patents have some clout. And we felt that if they were granted in the US, this would be strategically beneficial. So that was the strategy behind that. And the other thing I just wanted to point out at this point is you can see the dates that I put there. And this is really just to highlight how long things take. So we filed and got a priority date. This is when the date of the invention is registered. And you can see there, we're talking about 2003 and 2005 for those two patents. But those patents themselves weren't actually published in the public domain until a couple of years later, 3 years later in some cases. Again, there's a strategy behind that. You can try and get your patents published earlier if you want. There's still some constraints with the system, or you can try and hold it back as long as possible. And by holding back, you're preventing those patents going into the public domain and giving other people sight of what you're actually developing. And so sometimes these are referred to as submarine patents as well. In other words, they come up later and you find that people have already been working on things that you've been working on. But from a strategic point of view, keeping the patent secret and actually not talking about the technology, even though we'd established a priority date, gave us some advantage in developing the product that we envisaged further. And then you see at the end there that I also talk about the granted date. So not all patents get granted. You have to go through an examination process and you have to defend your patent and the claims that kind of construct the patent. And eventually, and you can see there, it can be quite a few years later, they're actually granted. Now, a granted patent has value in theory, but also the patent pending has some value as well in terms of the commercialization. So it's an important process, but you have to understand that the granted patent isn't an automatic part of that process. Okay, so next slide, please, Harry. So we developed those two patents, and we actually quite early on thought this would be a really good technology to spin off. This was actually the aim when we got the funding within the Institute. We said, look, we're going to take this forward. The aim is to be a spin-off. And in fact, we were going to be the first spin-off from IMRI. And this was one of our aims. And this itself created some challenges within the Institute because, of course, we wanted to do this from the outset. So we had to be very mindful of the conflicts going forward, that we were going to be developing something that was going to eventually become completely commercial, hopefully. And indeed, it was us that envisaged going out and doing that commercialization. So of course, universities, and particularly here in the UK, universities are set up with this in mind, in that they expect you in some cases to do research that's going to be commercially viable, and they want you to spin off or license. But when it comes down to actually doing it, any of you that had a go, you'll know that obviously it involves technology transfer offices, it involves licensing and all the negotiation that comes with it, which is what I want to talk very briefly about here. So a couple of things that we did. We quite quickly started referring to the project as Singular ID. And this was a project name that we actually envisaged and turned into the company name. So it eventually became Singular ID Private Limited. So it's a bit like Limited here in the UK. We did this strategically as well, partly to establish that trademark, not registered trademark, but a trademark Singular ID, but also because within the Research Institute, as we were doing this project, we did get publicity. I put one up there about some work we did with INSEAD and getting a business plan competition prize. We referred to the academic project as Singular ID so that when it became the commercial project and people searched on the name and looked to see what we'd been doing, the other stuff would come up that we were developing. So it would give more credence to what we're doing, and it would provide that continuity from being within the Research Institute and going out into the commercial world. The reason we chose Singular ID, obviously it's got Sing in it for Singapore, if you like. There are lots of Sings in Singapore, Singtel, for example, for Singapore Telecommunications. We did this because we wanted this project to identify with Singapore. And that was partly because we were negotiating this license agreement, and we wanted to make sure that, you know, I'm from overseas, my co-founder Toby was overseas as well. We were obviously expats working in Singapore, but we wanted to give it that local home feel brand, and that we were indeed committed to doing this and growing it in Singapore. Now, once we were at the mindset of commercializing, we had to do the negotiation. So what happens, again, very similar to here in the UK often, is that you need to engage with the tech transfer office, the TTO, and actually talk about how you're going to commercialize and license the IP that's been developed. And this is reasonable because, of course, the government taxpayer has basically been paying for the research up until this point, and you want to take it out and commercialize it as a benefit of a company. You need to have that license agreement in place. And Pete obviously talked a little bit about licensing and some of the pitfalls. In this particular case, Exploit Technologies Private Limited, which is effectively the technology transfer arm of A-Star, would be the licensor, and we, Singular ID, would be the licensee. And already you can see what the conflicts are. We're employed by the Research Institute to do the research, and yet we're talking about negotiating with that institution in effect to then actually take the IP out. So we had to make sure that we're in a position to negotiate. And the way we did it was we actually did, with permission, set up the company beforehand so that we have the legal entity established. And this meant that the legal entity would enter into the agreement for the license. And my co-founder and I were directors of that legal entity, concurrently with being an employee. And I guess the message here is this will maybe be different in different universities, but think through this in advance to make sure that when you are negotiating, you really do have that legal entity that can take the result of the negotiation in the form of the agreement. So we negotiated an exclusive license agreement. This was really important to us because we envisaged raising venture capital finance once we had spun off. It was, you know, a materials, actually more complicated than just a materials project, which meant that we needed venture capital, we needed financing, and the exclusive license would be really important in that point because investors coming on board would see that we had those rights. We were the original inventors, and then we had the rights to actually commercialize and take it forward. It actually was quite a long drawn out process. You know, ETPL, the commercialization arm, hadn't done that many spin-offs, but they had some pretty experienced lawyers who were well aware of some of the pitfalls as well that Pete talked about earlier, and making sure that, for example, sub-licensing was properly encapsulated. We actually wanted to be able to sub-license, and they, of course, were well aware of those pitfalls that Pete explained earlier. So it was quite drawn out, and I guess something we learned was actually you really do need to negotiate with the people that can make the decisions. So we quite quickly moved up through the ranks to actually be talking to people so that when we were negotiating, they could say yes or no about the terms quite quickly. And what we'd found earlier on was we were being pushed up and then being pushed back down. We weren't really negotiating with the people that could say yes or no early on. So be aware of that as well. And I think negotiation will come up in later sections of this series as well. Next slide, please, Harry.
So a quick question, Adrian.
Yes.
So you were talking about the length of time between filing a patent and it becoming published. How do you delay that publication? Do you just reply slowly to the patent office?
Yes, you can do it that way. Obviously, when you're doing this, you're working with your own patent lawyer, and they will have different, you know, ways of prolonging the process. To some extent, I think, and again, depends in different jurisdictions, you can also guide when you want it published. You can accelerate things through, or you can hold back. And I expect Pete has more experience of this as well. So
I can chip in a little bit. There are a number of regulations and rules about publication. But if you actually go back to the dates that Adrian displayed, you'll see that publication happened 18 months after the priority date. And that is the general rule. 18 months after the priority date, a patent application will be published. Now, there's certain things you can do, and there's certain strategic things you can do. You can actually withdraw your patent application before 18 months if you don't want to be published and you think there are good reasons for that, and you can refile, therefore starting that trigger 18 months all over again. So that's one way of delaying publication. But you have to understand the implications and risks of doing that, and I can go into that in another day, another tool. So that's one way. If you do nothing, it will be published after 18 months. But there are some things you can do. And also, if a patent is considered to be of strategic importance to a country for security reasons, for example, then again, publication can be stopped altogether or delayed for some time. So there are various tactics you can use to delay patent publication.
Yeah, thanks, Pete. That's right. Okay, good. So just a couple more slides to take you through the story. We then did spin off. So we had our license agreement in place and we raised some venture capital finance. And actually what we did quite early on through the publicity of the spin-off license agreement. So we actually turned that license agreement ceremony, if you like, into a newsworthy event. We got our first customer, and you've got a picture there of a air conditioning compressor that's used in cars. And these are actually subject to counterfeiting. And they were the first customer that we had in Singapore. And the label that I've shown there incorporates our technology. But what we found very quickly was in real life, applying the technology that we developed in the lab required yet even more iteration and development and some new inventions. So we're in a position to start filing quite quickly more patents within the spin-off company. And the important point here is that now we're in the spin-off company, we can assign those patents to that legal entity, and they're separate patents from those that we're licensing in from the university environment. A couple of other points at this point is, you know, we're now starting to incur quite a few costs. So you can imagine with each patent filing, first of all, it goes into the first country that you file, usually your home country, but then you start to elect where else that it's going to be filed around the world. In our case, again, we had to take a strategic view because, you know, this can become quite expensive. We were a small company, and so we looked at some of the major markets that we felt were worth protecting in. And I've put, you know, some examples there that we chose: United States, Singapore, China, Japan, and Europe. Clearly, China and Japan needed translation as well. So these are added costs that you have to think about as you're expanding the patent family. All of these patents need maintaining on an annual basis. You're going through the examination process, so there are examiner fees and so forth as well. Your lawyer is also, your patent attorney is also going to be incurring costs replying and maintaining this whole process. And another important point is, you know, it depends on the negotiation, but almost certainly you're going to be paying for some of the maintenance fees for the patents that you've perhaps in-licensed as well from the university. This very much depends on how you negotiate and how royalties might be used to offset that. But quickly, you're going to have quite large patent bills and other IP bills if you're not careful. But also on this slide, just to show you how the product morphed, you can see the box product there on the left as well. So what started off as just the materials technology very quickly became a system. And this included the reader, the tag, the material, the label that's in it, how that reader communicated with a server. So although I haven't gone into all of that technology, we started to encapsulate all of this thinking in the patents as well. So these new patents were really important. And then the final slide from me, please, Harry. With Singular ID, we actually went all the way through to an acquisition. So we experienced the exit end of the business as well. And we sold to a company called Billcare. It's in the public domain. They are a large international, multinational pharmaceutical packaging company. And they wanted to use the technology to protect medicines and pharmaceuticals from counterfeiting. So they bought the company. It was a trade sale and an exit. And I think the important point about the IP in this is that the IP had value. It had real value to them. They could see that we built this portfolio and that by buying the company, they too were able to protect what had been developed and then expand further. And I've shown a few photos there at the bottom of the next iteration of the reader, how it was applied to the blister packs, and indeed some more R&D that we did for further product development. And all of that as well created more patents and bigger patent families. You know, this was obviously a larger company, so had a bigger budget for IP protection, took the IP seriously, and we worked on more patents and indeed other types of IP that we've alluded to this morning, like design rights and trademarks and so forth. So really the message with this case study is, you know, what starts off in a university, a couple of patents, maybe some ideas in the lab, you know, you can take all the way through through growing a business and using that as a vehicle to then exit and get used by a larger company with bigger market reach. But be mindful of the importance right at the start, again, which Pete alluded to, which is got to get those agreements right, the license agreements, so that this process can run quite smoothly. And just to give you a feel, obviously, the license agreement had to carry on in place for the new acquirers of this company. And we had to make sure right at the start that we thought about that as well, so that it, so that someone that bought the company maintained the rights of the license agreement. So thanks. Any other questions? Obviously now we're at the end.
Thank you very much, Adrian. Just wait for other questions to come in, but from my own question, it might be a bit, sorry, you might have covered this as I was kind of concentrating on everything running. But what would you say was the biggest challenge throughout the process of patenting these ideas? And were there any other technical hiccups that came about?
Yeah, so we had a very good patent lawyer, actually. It was a patent lawyer that was originally engaged to work with the research institutes, and he and his firm understood what we were doing, and we worked with them very closely to kind of get that bit right. I would say one of the big challenges, particularly in the startup phase, when we're that small company, we're trying to raise venture capital finance and angel finance to fund the whole operation. And we were really mindful of the cost of the patents as we were going, both in terms of monetary cost, obviously maintaining it all, but also just the resource cost of both myself and my co-founder being involved in that drafting as the new patents were being drafted, but also answering all the questions that the examiners had and so forth. So defending the existing patents. So that can all take a lot of time and be a distraction as well.
Thank you, Adrian. We've got another question from Justin Burrows. Have you experienced any challenges by technologies that do a similar thing by uniquely identifying a product?
Okay, so you're absolutely right. There's, of course, competition. Back when we were doing this, and this was obviously a few years ago, we were obviously watching what the competition was doing, and indeed there were other patents being filed around other things. In this particular case, we didn't have to deal with any challenges. And now, obviously, I'm not actually involved in this anymore. So I don't know what's happened more recently, if anything. But no, we were fortunate in the period that I was heavily involved in this. We didn't have to defend what we were doing.
Brilliant. Okay, so we'll head on back to Pete's slides. Thank you very much, Adrian.
Yeah, if I can, Harry, I'll just say a couple of things on the example that Adrian gave. I think it's an excellent example of how knowledge of IP and business sense combined. Having knowledge of IP alone wouldn't have been enough, and I think Adrian would agree with that. And another thing which we haven't touched on, but I'll just leave as an open question: assignment or licensing, and what value does that create, and what dangers and implications does that have? So great example. Thanks, Adrian. And it ties in very nicely with some of the key messages that I hope portraying. And to move on, right, I'm going to do this next section reasonably quickly because I want to stick to the initial timeframes, and we've already had about 60 minutes, so we don't have a lot of time left. Now, I talked about IP awareness, and IP awareness is quite a broad thing, and one of the things that you should know if you want to start to understand IP and how it can add value is you should know about the fact that patents and indeed other forms of IP are recorded, publicly recorded, and there are great big databases around the world. For example, the US has one. Each individual country that has, well, most individual countries have their own patent databases, and there are companies out there which also sell proprietary software which crawls through and interrogates all of these databases. And this is a great source of information. And these are what I call IP analytics. And you can do landscaping to actually find out all sorts of things about your competitors, the market, where the IP is, what exactly does it cover, freedom to operate things, all sorts of really important pieces of commercial intelligence if you really understand how to use these IP analytics platforms. So if we quickly go on to the next slide, one of the projects I was involved with a few years back now was to do with Li-Fi. It's the equivalent of Wi-Fi, except you use light as the transmission media and not radio waves. And the people involved in setting up this young company were really interested in, well, who else are doing things here, where are they active, etc., etc. So I used the IP analytics platform, which I'm most fond of, which is proprietary, and I'm not going to mention that company unless people really want me to. And I did some searches. So I did a simple search on visible light communication, and you can see some of the data that came up in about 3 seconds. Okay, I had to edit it slightly, but you know, here are the main players. Where were they active? You can see that chart on the top right, and this is where they're active as far as their patents are concerned. And I could also drill into the patents to see, well, what exactly had they got, and how did it come close to what we were actually developing in our own project. So this is some of the basic information that you can get if you know about IP analytics. Really useful when you're building up a business case. We can go to the next slide. One of the other things you can do, and I was involved in the bio-nanotech project, and this is another form of landscaping. So I did a little bit of searching, again, finding out where the main players are. Now here is quite interesting because in the bio-nanotech world, it's really at the early stage of its maturity. And you can kind of tell that from the people who are patenting, because it's a lot of universities there as opposed to a lot of companies. And one of the landscaping pieces I particularly like is the ability to actually do a map of about all of these 460 patents, and you can see where there are crowded areas, you can see what the keywords are, and you can drill into each one of those patent areas and get loads and loads of information. So this is just an example of using patent analytics, and I'll just give one more quick example on the next slide. International patent classification analysis, or there's another one called the CPC, not the IPC, but basically there are some very widely accepted classifications of technologies, and these run into thousands and thousands of classifications in very well structured sets. But when you go into patent analysis, and I looked into a particular patent, and I looked into a set of nanotech in regen med area, and I did a crunch through, right, what are all these patents covering? And I found, for example, that the IPC A61 K47/48 was the most popular. And so you then find out what that is. And then people try sometimes to hide their patents, and you can actually search on these IPC codes and you'll find a lot more patents which are out there which are relevant to what you're interested in. So again, another powerful way of finding out certain commercial, intelligent, market relevant data. Next slide, please.
Pete, we've got a question from Steve. If a field has a large number of patents by big companies, do you think this is a problem? I.e., do you steer clear due to litigation or an opportunity?
Well, number one, it says that there's a market out there, so there's clearly an opportunity. And the fact that people have a lot of patents doesn't mean anything. You might only have one patent, but it might actually cover exactly what you want to do. You might have 100 patents, or the opponent might have 100 patents, and it might not cover what you're doing. So the number of patents isn't the question. It is, you have to, unfortunately, if there are a lot of patents, and this is what I call patent thicket strategy, you have to plow through them to actually see what it is they cover, where they cover, and does it actually impinge on exactly what you want to do. So one of the strategies that you can use, an IP strategy, is actually create a patent thicket. Just file and file and file and file. So you have 20, 30 or 100 patents. And most people will then say, well, I'm not really going to analyze that lot. I'm better take a license. So this is all part of strategic thinking and how much hard work and resource you want to put into actually exploiting your own IP. So hopefully that's answered that question. Okay, here's the sales and marketing piece. A very well-known international company produced flasks for growing cells, cell cultures. And these are the things on the left-hand side with a little red top. Now, the problem when you grow cells is that cells typically produce gas, build up pressure, and therefore you have to vent that pressure. And in the initial design, that meant someone had to go around these hundreds or thousands, if you're growing lots and lots of cells, had to go around and turn the top to release the gas pressure, then turn it back in again. This led to a lot of problems. Not only was it really boring and time consuming, but it also led to some carpal tunnel syndrome problems in the technicians. And so the sales and marketing guys found about this, because although their customers really loved the product, they moaned to the sales guys and the marketing guys, hey, this is a problem. So the sales and marketing guys came back to the company and they spoke to their manager, and the manager then spoke to the product design guys, and the product design guys came up with an idea. And the idea is, why don't we put a little vent or a valve on there, a one-way pressure release valve, and that would stop this problem. So they did that, and they went to the production guys, and the production guys went and produced it, and the customers liked it. But none of the guys I'm talking about were IP aware. They hadn't had an IP awareness course, so the sales and marketing guys, the product design guys, the manufacturing guys, none of them were IP aware. So they didn't even think about the IP considerations here. They actually had a problem and they solved it. This is a classic IP conundrum. If you have a problem, you solve it, you create IP. They could have actually got formal protection for the idea of putting in a one-way valve, but they didn't. Our competitor company saw this and said, well, we can't do exactly the same because that wouldn't be right. But what they did is they put a one-way valve that also included a microbiological filter. And they patented that idea. They got a granted patent. They captured the market. So the company A that actually should have captured that market lost it. They refused to take a license from company B because they were in the, well, they just got very angry with them. Eventually they gave in and had to take a license, but by the time they did that, they'd lost a whole load of market share. This is an example of why sales and marketing, product design, manufacturing, the whole range of things in the company needs to be IP aware. So these kind of mistakes do not happen. Can I have the next slide, please? A little bit to what Adrian was talking about, and indeed it relates to the example I gave in the introduction to IP tool. Be aware that IP is a territorial thing. Now, if you look very, very closely on this map, you'll see Britain, and that's got a little green circle, and that is my wonderful young UK spin out from university say, has got this great tech. Where are my markets? The red blobs are where my markets are. So do I actually have IP protection in there? So you have to choose IP protection which aligns with where your business opportunity is. So if you were going to take out IP protection, then you should certainly concentrate on where those red blobs are, and the size of the red blobs are meant to indicate the size of the market. So there, and not surprisingly, the US is actually the main market for this particular company, so that's where it should have really concentrated. If it's only going to take one patent out, it should have concentrated in the US, very similar to Adrian's example. So really think about that, and think about freedom to operate things, ideas. Who else has got patents out there which could block me? They might have US patents which block me, but they don't have anything in South America or Australia or India. Right, great. So maybe I ought to pivot my business model and concentrate on those areas. So that's another way of looking at IP considerations to address business model opportunities. Next slide, please. This is a sad but great story. I became friendly with a chap over a pint of beer or two, and found out that he was a researcher and he was an entomologist. So I thought, great, well, what do you think? What do you research? He said, I research solitary bees. Brilliant. And then we got talking, and he said, well, solitary bees nest in little tunnels, and you know, you can get these products where you put snipped off ends of canes, and insects and bees will come in and nest. Anyway, this guy had done some research, and he actually found the optimal diameter and the optimal length to for certain solitary bees. In this case, it was an Osmia rufa. And by manipulating the size of these little tunnels, you can also manipulate the ratio of male to female. And you want more female because they're great pollinators. They pollinate much more effectively than honeybees. And so and the second picture there is taken a few days ago in my garden, because we actually made a few products with these optimal things, and I have bees now whizzing in and out, making their little nests and what have you in my garden, which really helps the pollination of my fruit trees. Well, business model, thinking. So that was the first thought. Let's get a little retail thing which we can sell in garden centres. But then we said, hey, well, there's something better than this. There are some massive fruit orchards, particularly again in the US, the almond orchards, where the orchard owners actually make botanical deserts, sorry, not jungle, botanical deserts. They get rid of all competing other plants and flowers. So bees don't like that. So we then went on and designed and patented a portable on-site incubator for bees, which you can put in these orchards. And there was all sorts of clever tech. So this is an example of a discussion, teaching guys about IP, because the entomologists didn't really understand anything about this, design, setting up little companies, selling a little product, and then business, hey, we can actually do product extensions. In the end, I advised them in the early stages of this company. In the end, that company went bust because of a lack of business sense, and that's another story for another time. But another interesting example of how IP helped grow a little company. Next slide, please. I believe, and I hope I've managed to convince all on the call, IP is an important asset class. You think about Adrian's examples, forget mine for example, think about that name, Singular ID, what a great name. That had real value, and I bet you the acquirers really like that name. It had market presence. I think that's a lovely name, that. I think all businesses should consider having an IP strategy. It doesn't mean to say you have to take out formal IP. What it means to say is you should recognize that you have IP, because all companies will have IP, and you should decide what you're going to do with it. And setting up processes and systems is really quite simple to increase that overall IP awareness. Do not fall into that trap which those cell culture people did, who made those flasks. So the success of all of this depends on not just what the knowledge of IP is, but you need that, but a wider awareness across the company, and make sure you align whatever you do with IP with your overall business strategy. And above all of this has to be combined with good business sense. And on that happy note, I shall finish the talk and happily try and address any questions.
Thank you very much, Pete. So we got a question from Justin. If a small company just has experience rather than patents or a specific product, is it still possible to leverage funding throughout the spin out and growth process? Can technical knowledge and experience be marketed?
Well, the simple answer is yes. If you think of, let's go back a little bit. Let's go back to some traditional industries, which actually have a lot of IP, but very, very rarely register any IP. Let's go to saddle makers or boat builders or people like that. Why do you go to them? Because they have great experience, they know what they're doing, and they can do what they do better than you can. So yes is the simple answer, but you need to get market traction. So marketing, therefore, becomes really, really important, and your brand name might become really, really important. But yeah, you don't have to have all these patents and design rights or plant breeder rights or all this wide range of formal IP that you can have. But I would suggest that market presence, brand name, company name, and good marketing is a perfectly adequate way of establishing a good business. Does that answer the question?
I was going to just add there, you know, in terms of university research and tech, you've got the opportunity almost certainly that you've generated some additional IP as well. So, you know, even with a tech company, yes, you've got the experience of how to do certain things, but because you've got that added bonus, if you like, that you probably can protect something. And I think that's why it becomes more valuable if you can.
And IP actually, if you really understand the range of different types of IP, there are very few things that you can't protect. You know, from works of art, music, shapes, all sorts of things. The get-up of a product, which is how it looks and what the logo is and the color of the design of the packaging. All of those things can be officially protected. But as I say, you have to understand this to create your own IP strategy, and branding and market presence is a perfectly good IP strategy.
I have a question as well. So in terms of, you talked about the IP thicket or the patent thicket. Let's say you're an SME and you've got a very small budget and you can't necessarily afford a patent attorney for a long period of time. And you've just got lowly researchers like myself going through the patent literature. Do you have any recommendations for that? Any kind of advice into how to leverage a bit more support?
Well, yes. Now, however, you're in a very vulnerable position. If you're a small organization or an individual and you think you have some IP that you want to, the only reason for doing this is because you actually want to exploit it and create commercial advantage. If you want to do R&D, although the rules differ, in some countries you're allowed to use anybody's IP for R&D purposes, in other countries you're not. So you have to understand those rules. But the only reason I'm going to assume that you, the small guy with little money, has some IP and you want to commercially use it for your advantage. You are aware, for example, that big guys out there operating in the same field, and you've done a tiny little bit of search and you found that they've got loads and loads of patents. What do? You're kind of in a difficult situation, because unless you've got the money and the resources, you cannot do a really proper job. So one of the things you can do is actually approach that company and say what it is you want to do, and ask them whether they've got any IP in the area, and therefore they'll actually go into their thicket for you and come out and say, yeah, we've got this, this and this. That kind of then diminishes, because then you can have a look at what they say they've got. And it's quite surprising. Lots of people have IP which they believe covers a particular technology, whereas in fact, when you look at it, it doesn't. You have to look, again, I'm talking about patents here, and I'll talk about other classes of IP another day. You have to look at the claims, the specific claims, because number one, you can only assert a granted patent. So Adrian's point about the time frame to get a granted patent is really relevant. You cannot sue on a patent which hasn't been granted. A patent is not considered to be valid until it has been granted. So that's kind of interesting. A pending patent does have value, but one of the values it does not have, it is not the basis for a suit. So first of all, find out if they've got granted patents, not just a lot of patents, but have they got granted patents? Secondly, if they have got granted patents and they point some at you, have a really good close look at the claim structure, because you'll be surprised in some cases how limited their scope of their patents might be. So there are things you can do, but this goes back to one of the first examples I gave you, which was Smart Strategy. Remember that company I was involved with? It had no money. In fact, it had debt. So we had to think very carefully about, well, if we're going to exist, if we're going to survive, we need to be able to exploit our IP. How the hell do we get the resources and funding? So try as hard as you can to become as independent, because if you're small and weak, you are in trouble. The only other thing you might like to do, but again, it's a cost, is think about IP insurance. Another subject for another day, but there are specialist insurers out there who will insure your IP rights. So that is a possibility, but again, it costs money. If you don't have money and you don't have resource, you're in a bit of trouble.
Thank you very much, Pete. We've got a question from Steve Dixon. Do you think that the startup IP and investment culture in the USA is different to what we see in the UK? Does it put UK startups at a disadvantage or not really make much difference? Should we always...
It makes a load of difference, and it's all to do with perception of risk and risk management. And also it changes quite interestingly across the US. I'm currently in discussions with a number of investors for a number of projects. And the attitude of the guys I'm talking to in the West Coast of the US is different to the attitude I'm talking to of the guys in the East Coast of the US. So all sensible investors will demand sight or proof of what they're investing in. Some are more easy with potential future value. Others really want to see, well, what is the value created today as a basis for me understanding future value? But yes, in essence, there are a range of attitudes exhibited by investors. It's not to say that you can't get really good investors in the UK. You absolutely can. But as a generic statement, the UK investors are more cautious. They tend to invest more slowly. They tend to put in quite intense milestones, and they try to really, really control. That's a generic statement. It's absolutely not true for everyone. Whereas the West Coast American ones, which I've worked with, tend to be a little bit more laissez-faire, a little bit more forgiving. But ultimately, you do have to deliver, because investors will not keep investing on something which doesn't deliver. So if you make a business plan and you state you're going to reach these objectives, you either reach them or you manage expectations if you're not reaching them. So I think, yeah, the short answer is there are differences. I would say that in the UK, we're kind of hamstrung a little bit because a lot of people invest small amounts. And if you have a lot of small investors and then you try to up it to the next round, you can get into all sorts of unwanted issues and problems. Adrian, you might want to comment on that from your experience. I don't know.
Well, I agree with you. I think, generically, or, sort of being very general, yes, the US, I think, takes more risks. And I think also there are more investors there as well. There's more money there to invest, particularly in tech startups. So they will probably punt more, have a bigger portfolio, and so forth. The question also asked about other parts of the culture, the IP culture. I think in the UK, we have quite a strong IP culture. We understand IP. You know, all the universities talk about the importance of protecting it and creating it. But I do think we're not very good at actually commercializing the IP, which I think the US has a much bolder attempt at doing.
Yeah, and I think a large part of that is the investment issue. It's interesting though what you say about universities, because yes, they're very keen on IP, but they absolutely, in my experience, very rarely defend it. They don't spend money on defending it, and they also bottle out quite early in the actual creation of the IP thing, because it's very rarely they take it through to national phase, particularly if you're going into the Chinas and Japans of this world and the like. So I think there's a little bit of hypocrisy there in the university world. They place a lot of value on IP, but they don't actually put much resource into creating a proper IP culture. That would be my contention. I'm sure I'm going to get a lot of nasty letters now.
Thank you both.
It's James here. I reiterate what you just said, Pete. I think a lot of people, certainly in the UK, I find are very obsessive about patents, kind of never mind the quality, feel the width. And as you described in your talk very well, and also backing up what Adrian said, its patent has to have a context. It has to have people to operate it, to control it, to understand it. And there's a lot of internal know-how that a lot of people don't understand and don't appreciate, and it's all part of the package around the patent. I mean, the way I looked at it when I did a project a long time back defending agrochemicals against wicked parallel imports from other parts of the world, was a bit of like a medieval defense. Like, you don't just want a castle, is the archers, the burning oil, the stakes, everything. So just make it difficult for your opposition, but don't underestimate the power of internal know-how. And in some parts of the world, some industries, I worked in the steel industry on some bizarre heating technology, and the steel industry would just steal it and stick it in a plant and say you can't visit the plant. So there was no way you could understand what the heck was going on, because you could never visit the plant. But you know that they'd read the patent, developed their own version, and nobody could steal it. So
Dave, you make some brilliant points, and one of the tricks of the trade. I mean, we talk about this for hours. You're going to have to stop us at some point. But one of the tricks of the trade is having IP which has a little thing in it which the other guys don't recognize, but if someone else infringes it, their product or service will actually exhibit this particular thing, and the only way they could have found out or use that particular thing is through your IP. If you have something which is a generic process and they hide it, like James says, it's sometimes really difficult to police it, because people aren't always ethical. I had a classic case where I talked to two, and these are really big, well-known names, pharmaceutical companies, and I said, I believe you're using our IP. I was working for a particular company. One company said, you're right, we should have talked to you, we'll take a license. The other one said, so prove it. And they just didn't volunteer anything, and they wouldn't let you get into their site. So yeah, it's an interesting world, protecting IP.
Thank you all. I'm just going to have to cut in as we've got quite a few questions coming in. Next one is, what would be a typical annual patent budget for a small company business plan?
Right, well, I can answer that in a different way. If you are filing a patent and you decide to take what I call an average global coverage of, say, if you're in the UK, let's say UK, let's say 4 states in Europe, let's go for Germany, Italy, Spain and France for the sake of argument, let's go for the US, and let's go for one Asian country, let's say China. It's going to cost you around about £40,000 before you get a granted patent. The time frame to get a granted patent can vary enormously. The quickest that you're ever going to get a granted patent, I would suggest, is about 3.5 years. But as you actually saw in Adrian's example, it can take considerably longer. That is the cost of getting the patent. But you should also budget for the management resource and the other resources you need to wrap around that to actually make value of all of this work and investment. And so then multiply that out. Is one patent all you want, or do you want trademarks? Trademarks, if you register trademark, you register copyright, or you register other things, that's all going to cost you money. So depending on what you are, let's just say you are a small company, let's say you're in a technical field, let's say you're in life sciences, I would say, depending whether you're actually getting products out there or not, because that is also another major determinant, but let's just say you're in the product development stage, I would argue you probably want 50 grand a year as a overall patent budget to cover all the time, the people, the patent attorney fees, the official fees, and all the other things that you need to actually make sure an IP strategy works. And then compare that. Let's just say one of your strategies is to do a license, and then compare that to one successful license deal. If one successful license deal is going to net you £100,000 up front with a revenue of, say, £1 million over the next 2 or 3 years, that's a pretty good investment. But if you don't have that kind of return in mind, ask yourself, well, what are you doing? Are you just spending money for the sake of it? What is the business here? Why are you taking out these patents? Why are you actually creating that cost? This is why knowing what IP is one thing. Actually having good business sense is the only way of making it work.
Thank you, Pete. Should you believe all the data you read in patent literature before it is granted?
Should you read, or should
believe?
Well, what do you mean by that? What you have are patent applications which become public so you can read them. You absolutely believe that that's what they say. What you can't believe is that they're going to get claims which mirror what the applicant actually wants to get. Because what happens in effect is all patents are examined, as Adrian said. The examiner's chief role, in most cases, they're under strict instructions to only provide IP protection scope that is justified by the data that the inventor or the applicant puts in. So typically the patent applicant will try and claim all sorts of things. Typically through the examination process, the eventual claims will be narrowed down to something very specific. So what I would do when I look through ungranted patent documents, I simply note this is what the guys think they're doing. This is what they are probably going to try and claim. But until the patent is actually granted, I don't actually believe they're going to necessarily get that scope.
And the other thing I would add is one of the things you can do in a patent is you can write at length in the description. And obviously, as Pete just said, what it really boils down to is what's in the claims. But what we used to do as a strategy was we almost tried to confuse the reader. But what I mean by that is we would write quite lengthy explanations and descriptions. As long as the key bit of information is in there somewhere, you're trying to hide it so that if people are trying to reverse engineer or get around the patent, they've actually got a lot of work to do to work out exactly which is the optimum formula or ingredient, etc. It has to be in there and it has to be part of the ultimate claim. But if you read some of the patents that I sort of cited in my presentation, you'll see they're actually pretty long. We did that on purpose. And the other thing is you have to offset that against cost because obviously when you write a very long patent, it's got to be translated, and that, you know, the length of the patent does play into the cost of the translation.
As
also,
do the claims.
Yeah, as the claims, yes.
And another way of doing exactly what Adrian says, and I've done this, is actually put the most important claim in the hierarchy of claims at number 27 as opposed to number 1, because sometimes people don't bother doing their homework properly, and you catch them out because the really commercially important thing is in a claim which is well down the hierarchy of claims. So there are lots and lots of tricks here, but again, it's just really having the knowledge of the difference between what a patent applicant wants and what a granted patent might actually give them.
Thank you. So we've run over time a little bit, so I'll ask for a very quick answer to a rather complex question. How easy is it for a spin-out business to become totally independent of the university it originated from?
It's exceedingly easy. Just get a load of investment. If you are relying on the university for lots of things like resources and IP and all sorts of other stuff, then you're not going to become independent. I think Adrian gave an example, and I can talk to many, where independence of the university or the host organisation is a valuable thing, but never forget that the link with that university or the host organisation is also a valuable thing, because they're going to have great standing in the world and people are going to respect the fact your technology sprung from that source. But to get independence, and this is why I threw the question assignment or licensing is an important consideration, is, I think, very valuable. And the only way you're going to do that is through making sure that you have enough resources to become independent.
And indeed, the question asks, about percentage of equity taken and so forth. So, that's all in that original negotiation. When you're putting together your license agreement, be really mindful about the equity that's being asked for and getting that reduced as part of your negotiation. They may ask for seats on the board and all kinds of things. So all of those impact that eventual independence, but probably you will always have a tie back in some form or another, whether it's royalties or some equity stake with that original institution. Yeah,
absolutely. And maybe, James, we could have a session, I don't know, sometime in the future on shareholders agreements or articles of association, which address a lot of these points.
I think that's a good idea. Just to the previous one about the independence, I think certainly what I've seen is the pattern is that most universities, broad brush, wild generalization coming up, put a far too high a value on patents themselves. As it's eloquently explained today, that the patent itself has a value, but only if it's part of a complete package. Also, from a commercial point of view, you may have discovered a wonderful thing and patented, but that may be a very long way from becoming a commercial product. I mean, for example, pharmaceuticals is a classic one where the patents really do count because you are effectively putting the recipe on the internet, maybe not the recipe, but the final product. People can reverse engineer it. But you've got 10, 15 years before it actually becomes a product. So you've got some time to do that. I think a lot of people over patent in the UK. I'm a know-how fan, and I like to keep things in-house. And then there's no question about it. It's nobody's going to bother you because it's all in-house. And then you've got another issue is that the key employees walk home every night and they might get hired by somebody else. But that's a subject to another class, another discussion.
Thank you very much. So with that, we'll draw a close to the session. I'd like to thank you all for joining. It's been a really interesting chat today. I'd like to thank Adrian and Pete for giving their talks, and James and Lucinda, who sat largely in the background today, but will be present in future sessions. We intend to run these sessions weekly at the same time. The times might change depending on how long these sessions take, but we'll be running weekly on Friday from about 10 till around 11:30. We'll be missing next week because of the bank holiday. So we're restarting this hopefully on the 15th of May. The next session will be on finance. I don't know if James wants to talk about the next few modules.
Yes, indeed. I mean, I think for technology business, every technology business has IP, as Pete explained, but also every business, every time you step outside to the real world, you will need to understand finance. And what we found, I've been running this course at Southampton for some time now, is that finance is absolutely pivotal to a whole lot of understandings. We touched on it in the introduction last week, but basically if we go through an hour and a half and go through the importance of finance, what you need to know. You won't come away as an accountant for sure, but the idea is to give you a feel for how the various financial statements fit in with each other, and the importance of finance. A bit like this one, which is basically an introduction. A lot of people think financial information itself is important, but it's actually what you do with it's also important. But we've got a very simple, easy to understand session around, let's talk finance, and we'll put together some case studies as well. But you're welcome aboard and look forward to doing it in a couple of weeks.